Right, I think we can start. Good evening, lovely welcome to you all attending in person, and a warm welcome to people who are joining us online. This is a hybrid event. My name is George Letsas, and I'm the convener of the John Austin Jurisprudence Seminar Series at UCL, and I'm delighted to introduce and welcome today's speaker, Kritika Maheshwari, who is joining us from the Delft University, Technical University of Delft in the Netherlands. We are extra grateful for her that she's here, given the fact that she had a quite adventurous trip this morning. She couldn't board her flight and she spent several hours at the airport, and she actually just barely arrived in time for the seminar. So she must be exhausted, and we're very grateful that she persevered and she managed to be here today. Kritika is a legal philosopher. She holds degrees from the University of Groningen and the University of Birmingham. She did her PhD on the ethics of risk, or pure risk. It's a topic that she still is working on, and we'll hear more about it today. She has a wide variety of interests. She's interested in artificial intelligence, health law, climate change. And today she chose to speak to us about pure risk and duties of compensation. It's a topic with both a philosophical and a legal dimension. The topic of why risky behavior may be both morally and legally wrongful is one that has been at the forefront of private law theory for a number of years now. And Kritika has contributed significantly to this debate, and we are looking forward to hearing more about it today. So the title of the presentation is No Harm, No Foul, No Remedy. And just to remind everyone the format, so Kritika, this is not a pre-read session. There was no paper in advance. Kritika will speak and introduce her ideas for about 30 minutes, 35. There's a handout for the people in the room that has been circulated. There's more copies at the corner here, if anyone would like to grab a copy. So Kritika will speak for about 35 minutes or so, and then we'll go to Q&A. I will open it up for discussion to the people in the room. So without further ado, Kritika, the floor is yours.
Thank you so much, George. It's nice that you sort of shared the story of me not boarding my flight today, because as it was happening, I wasn't thinking about this in the moment, but in hindsight, I remembered reading from John Gardner's Personal Life to Private Law, that he illustrates this example of him also having missed a flight because of a storm when he was about to give a talk at Rutgers. So this is not to say that you should hold me to the expectations of John Gardner by any means, but it relates quite well to the topic of what I will be speaking about today, which also relates to what he was talking about, which is the role of continuity thesis as he formulates it. And essentially, before we get into the nitty-gritty details of what I'm going to sort of argue, the idea generally is to try and think about the extent to which we can engage the continuity thesis in order to say something about wrongfully imposed pure risks. What does that mean? I'll sort of get into it in a second. But the central question that I'm asking sort of comes from this idea that agents who generally wrongfully harm others often incur corrective duties to compensate their victims, other things sort of being equal. So what about agents who wrongfully impose serious risks of harm that never materialize, also known as pure risk, as Judith Thomson sort of coined the word in 1978. And to think of a very clear example, today, the fact that I was at the risk of not making it to the seminar today is a risk that was imposed on me by the airline company. Now, the risk didn't materialize because I'm here right in front of you, but did they wrong me by imposing that pure risk on me? And if so, do they owe me compensation? So we'll try to see how we arrive at that answer, but to sort of take away the surprise of what I will say is that in some cases, yes, wrongfully imposed pure risk do generate corrective duties to compensate. Now, how do I get to that claim? I start by sort of thinking through the question of what makes pure risking sort of wrong in the first place. There's a number of sort of cases that you can think along with me. Within legal theory, they probably fall in sort of different domains of law, but within moral theorizing, there's less of categorization. So people talk about playing Russian roulette with someone without their consent, reckless driving, or sort of distribution of unsafe products as typically sort of the kind of risk that we call instrumental risk imposition. So the idea really is that in these cases, we impose risks on other when the harm or the risk of harm itself is either intended to be constitutive of an agent's goal or it's a direct means of securing that goal. And those kinds of cases are quite different from what you might call your everyday incidental risk. So just merely going for a walk or driving to the supermarket, they impose risks on others, but they're usually discussed under the category of socially accepted risk or everyday risk, where we all kind of share mutual benefits. But that's not really the case with instrumental pure risks. That would be my concern today. And with that come two widely held intuitions. So the first intuition is that impositions of pure risks are morally wrong. And not only are they morally wrong, but they also morally wrong others, and in particular, those who we subject these risks to. And the second intuition is that when that happens, it seems that it's not enough for the risk imposer to kind of do nothing at all about it, to just walk away. Some people think it's also not enough if they apologize or if they just give an explanation for why they did what they did. But also at the same time, in the absence of materialized harm, it's also not clear what there really is to correct or repair in the traditional sense, at least insofar as we're working within the realms of a harm-based form of paradigm of compensation. To try and make sense of these intuitions and what we can say about them, I want to start with the first one, where we seem to think that at least some pure risk impositions are morally wrong. And to kind of categorize the different variety of views that are out there, especially in the philosophy literature, I've coined these terminologies, unificationists and isolationists, as just a way to categorize the different sort of spread of views that are out there. So the idea underlying unificationism, or what I call unificationism, is that there seems to exist an explanatory relationship between the fact that pure risking some action, let's say pure risking harm, for the sake of it, is wrong, and some general moral fact that harming is also pro tanto wrong. This comes from the intuition that if at all pure risking is wrong, or pure risking harm is wrong, that must have something to do with the harm that you're risking, the wrongness of that harm. And there's an explanatory relationship between the two, even though yet we have to still specify what that relationship amounts to. Any sort of view, especially in the philosophy literature, that tries to draw upon this relationship or to explain away this relationship, kind of in my terminology, falls under the unificationist camp. And to give you a contrast, we have the isolationist or isolationism, which explains the wrongness of some act type pure risking harm by way of isolating and referring to substantive wrong-making facts or features that are quite distinct from any sort of facts that make the wrongness of the harm itself wrong. So the wrongness of the risk act type phi in this case. So we have a variety of accounts on this side of the camp as well. So people have talked about how the wrongness of pure risking is explained by the fact that the risk imposer is disrespecting the victim, that in virtue of risking, they're also reducing their overall negative freedom, perhaps even their autonomy. Perhaps they're even harming them just by the sheer fact that they're being exposed to risk. All of these explanatory features of what is wrong with pure risking are very much isolated from any wrong-making features of the thing that the person is risking itself, which is a way to say that they've isolated the wrong-making features in this case. So views that are kind of on that side of the camp are not going to be of interest today, at least as far as my argument goes. What I want to push for, in at least the first part of this talk, is the unificationist view that tries, or at least aims at unifying and explaining the morality of some act type pure risking phi, let's say pure risking harm, in relation to that of harming, even in cases where the harm never materializes. So what would be some reasons for taking this kind of a unificationist explanatory view seriously in the first place? And in my previous work, I sort of try and motivate it by terms of at least 5 kind of different examples. So the first very simple way of motivating it is to say something about how our ordinary sort of moral reasoning kind of already reflects this explanatory relationship that I'm after. So often in the way we sort of talk about what's wrong with risking, we often say, well, pure risking particularly, we often say some things like, well, you could have actually harmed someone. Or when you've not yet risked and you're trying to sort of object to someone risking, you say, well, you could harm someone. So there's already a kind of relationship that we seem to draw, that risky acts are objectionable in virtue of the outcome that they risk, even if the outcome doesn't realize. The second kind of reason you might think is maybe digging through some kind of moral theorizing and to see whether people also already hold on to some pre-theoretical commitments to something like unificationism. So one example is to think about Shelley Kagan's sort of famous problem of paralysis for various sort of deontological constraints against harming. According to Kagan, the problem arises considering the idea that it cannot only be actually causing harm to someone that's forbidden by the constraint against harm. Some forms of merely risking harm to others must also be prohibited. And you can for now keep aside any kind of significance and implication of this problem for our sort of general everyday conduct, but it does seem to indicate that the problem itself is rooted in and also suggestive of some kind of prior connection between the morality of actually harming someone and the morality of just merely risking harm on someone. That is sort of another way you can motivate the unificationist thought. Another one comes from this observation that there seems to be some co-variation in the degree of wrongness of, let's say, harming and that of purely risking harming. So just the sheer obtainment of this conditional that is stated in cases of risk, and sort of in some cases it obtains, but in the cases it obtains seems to motivate the unificationist thesis. And the motivation comes from the idea that on some, if not every occasion that the conditional holds, the reason why purely risking harm is pro tanto wrong refers to the reasons why harming is pro tanto wrong, or even all things considered wrong. And finally, just as a matter of fact, there seems to also be a kind of relationality here that obtains. So pure risking harm is, in fact, a four-place relational property in cases that are of interest to us. It holds between an agent who subjects risks onto someone or something, the probability of some unwanted outcome or harm obtaining, and the risk outcome itself. And that, because of that precise relationality, it also seems very natural to think that if pure risking cases are morally significant, then their significance is partly explained or partly captured by facts about what it stands in relation to, such as the facts about the wrongness of the risk act or the outcome that fails to realize. And that itself also suggests something like a unificationist picture of what's wrong with pure risking cases, even in the absence of harm. And with that, I kind of come closer to a proposal that I defend, which I call the simple account, which is basically trying to address the question of why is pure risking harm, let's say, wrong. And the claim that I make is that when it is wrong for an agent to purely risk harming, the fact that it's wrong for the agent to purely risk harming is grounded directly in a general moral fact that harming is pro tanto wrong, simply, and period. That's sort of the very simple unificationist claim that achieves the aim of that unificationist goal, which is to unify these two sort of morally relevant features. And it tries to do that by saying that whenever we think about why pure risking cases of harm are wrong, it's simply in virtue of the fact that the general moral fact that harming is wrong is what makes it wrong. To kind of put some more intuitive juice into it, the way I try to motivate is by saying that when we think about risking some harm, it's very similar to some agent's act of trying to harm, let's say. And that may be thought of, and in that sense, risking harm may be thought of as some kind of an incipient act of harming. And often it's considered by philosophers like Matthew Hanser that the wrongness of any kind of incipient act, such as trying to do something, can also be evaluated with reference to which they could become or in which they could culminate, even if and when trying to harm ultimately proves unsuccessful. And what I say is that something similar can be said more generally of cases of pure risking, even if and when pure risking is not strictly always an act of trying, nor an incipient act of harming. And in particular, what we could say of the agent that has done something wrong in pure risking harm, in virtue of the general moral fact that harming is wrong, it is because he was at a particular time risking that which could have culminated into or become something that was, in the right circumstances, wrong to do. And as such, if it is wrong to harm, then this very general moral fact licenses both kinds of judgments of the form that the agent acted wrongly insofar he was harming, and also the fact that the agent was acting wrongly insofar he was risking harm. But when I'm trying to think about whether cases of pure risking harm generate corrective duties, and in particular directed corrective duties, just making some claims about why pure risking wrong, especially in relation to the harm that never realized is wrong, is not going to be enough. What we would also need is an account of wronging. It's in pure risk, as I said, pure risk imposers don't merely act wrongly, but they are also wronging others, in particular those who they're subject to risk. And that's important for my purposes, at least, because I want to capture that correlativity of corrective duties in this case. I want to know why it would be the case that the pure risker is the one who owes these corrective duties to the people they expose to risk, even though they never end up harming them. And that requires some kind of a structural modification to the simple account, as I call it, from an account of wrongness to an account of wronging. So why do pure riskers wrong those they're subject to realized risks? The answer is in virtue of the general relational moral fact that for any agent A and B, A is harming B is pro tanto wrong to B. And this general relational fact is not only explanation serving, but also it involves an explanation. So to kind of explain why I think this general moral relational fact, which speaks about the general moral wrongness of some agent A harming some agent B, and in doing that, wronging the other person holds, is because of some kind of generally accepted idea that general moral facts as such, which in philosophical debates we also refer to as moral principles, like killing is wrong, keep your promises, they do play a fundamental role in general in morality. And those who sort of accept this role also hold that one theoretical function of such general moral facts or moral principles is that they are in fact explanatory in nature. That is, general moral facts or principles play a special role in explanation of moral phenomena, and accordingly, they're considered as explanation serving and not only explanation involving. And here, I sort of make a distinction between a particular general moral fact and a particular moral fact and a general moral fact, where I think it's only the general moral fact that's doing the explanatory work that we need, even in the absence of formal. And the way to kind of bring these or tease these apart is to say, well, a moral particular fact would be a fact about my particular actions against some other person. So it's a fact about a particular dated, maybe a non-repeatable thing, such as a particular action that I take or a particular person takes or a particular kind of state of affairs. And it only grounds particular concrete token instances of that type when it obtains. So for example, Bill's killing Joe is a concrete token action that obtains when Bill, in fact, actually kills Joe. And by contrast, a general non-particular fact, which includes general facts like pain is bad or killing is pro tanto wrong, they don't ground in a time-bound or in any world-bound way. They're facts that we consider as fundamental, and they're also considered to be ungrounded in a more metaphysical language, if you like. And they're widely assumed to obtain as a matter of physical necessity. And this kind of metaphysical grounding helps us to understand why a general relational moral fact that relates any agent A and any agent B, and the fact that A is harming B is generally pro tanto a kind of wrong to B, helps us to explain why even in the absence of actually wronging B by actually harming them, we can bring together the explanatory relationship between why pure risking harm in the absence of that wronging actually obtaining can be used as an explanatory factor. We can get into the more specifics of how this works in the Q&A if this is not clear enough, but the general idea is that even if no harm occurs, the explanation for why B is wronged, let's say some agent B is wronged by A's risky act, can be grounded in some general moral fact that is about the wrongness of the harm itself, that one is risking. So the wronging first simple account tries to get close at explaining why purely risking harm can sometimes wrong others. But explaining why the act is wrongful does not yet explain what the wrongdoer owes. So when wrongful harm occurs, generally we recognize some kind of secondary corrective duty of repair or compensation. But in cases of wrongful pure risk, when no harm eventuates, it seems that the pure risker still ought to do something instead of just walking away from the situation. That's the second intuition that I spelled out. So that raises the question, well, what kind of duty, if any, arises from a wrong of pure risking? This is where I bring in Gardner back into the picture. The idea is that sort of Gardner that spells out in explicating his continuity thesis is that he's offering us a general framework that links primary duties like duties not to harm to secondary duties like duties to repair. The idea essentially is that when we breach a primary duty, our moral obligations don't simply just disappear. Instead, the same underlying moral reasons that made the original duty binding continue to exert some kind of normative force on us. And on his account, secondary duties like duties to compensate are what he calls rational echoes of the primary duty. They're attempts to satisfy those same reasons as best as possible after the breach. So in other words, secondary obligations represent the best next available conformity with the moral reasons that underlie our primary duty. And that's sometimes captured by the slogan, he says, obligation in, obligation out. So once a moral reason grounds an obligation, that reasons continues to demand some kind of conformity, even if perfect compliance is no longer possible. Now, the way I sort of read Gardner, I seem to think that there's a kind of a natural link between the unificationist structure of why pure risking wrongs others in the account that I spell out and the continuity thesis. So the way I see it as in their own ways, they both appeal to some kind of persistence or continuation of underlying moral reasons to explain different moral phenomena. In my case, I'm trying to put forth the account of wrongness or wronging others by appealing to some kind of continuation or persistence of general moral facts that relate to harming and how that explains why risking that harm is wrong, even if the harm doesn't realize. Gardner is kind of appealing to some kind of continuation in order to explain duties of correction. So there, at least at sort of the level of a sense, you might say, there is a natural link. And for me, that already makes the continuity thesis as at least an emerging attractive option or a candidate for understanding why wrongful pure risks might generate corrective obligations in some cases. The continuity thesis applies to cases where we've in fact breached obligations or committed wrongs. So you might say, well, pure risk should also clearly fall within the thesis scope because there is, as I'm claiming in the cases I'm concerned with, there is actual wrongdoing on part of the risk imposer. So on the face of it, you might say arbitrarily kind of removing cases of pure risk from the thesis scope might sort of require some justification. It seems like Gardner does not himself very much engage in that question of pure risk, but some other people in the literature have, and they tend to come about to saying that cases of pure risk do not generate duties of compensation. And my kind of challenge to them is to say, well, why not? So one kind of tension that I see that emerges when you try to link these two together, and I'm trying to just extrapolate from why they might be thinking that the continuity thesis does not help us here in trying to say anything about wrongful cases of pure risk, is because the continuity thesis itself is developed in the context of talking about what we might call completed wrong. So acts where a primary duty, example, not to harm, not to steal away someone's property, has been fully breached, right? So the continuity relationship presupposes a realized loss or injury. There has been a change in the moral landscape that now calls for rectification. And the secondary duties on Gardner's account are, in fact, responding to exactly this realized breach. So there's a sense in which there is a dependence on the outcome of what happens when someone breaches. And because of that outcome dependence, it seems that the continuity thesis would struggle to explain cases where the unwanted outcome never realizes. So cases where the wrong exists without the realized harm, like in the cases of pure risk impositions. So in such cases, you might say that the primary duty, let's say not to harm, has not been reached with respect to the realized outcome. No harm or loss materializes that could now serve as the object of what we need to correct. So the intuitive sort of moral remainder that we feel in sort of very problematic cases of pure risk, that, you know, the risk imposer can't just walk away, they must do something, they must do more than just merely apologize, cannot immediately be captured under the continuity thesis, traditional sort of outcome-based or harm-based logic, let's say. And I think that is exactly what drives someone like Sandy Steele to get basically to the conclusion that the continuity thesis does not support that risk imposers owe any corrective duties to those who are in fact harmed. Even though the kind of example that Steele sort of frames this discussion as are cases where someone is in fact harmed, but it so happens that it's unclear whether the two people involved, one of them clearly whose actions didn't culminate into harm, whereas the other does. His question really is about whether both people are now kind of, you know, to be held liable for compensating this person. But essentially what he's also trying to get at is saying, well, because one person imposed merely a pure risk of harm is why that person does no longer hold any corrective duty. And his reasoning really is that the secondary duties are tied to this undoing of realized losses or harms. And without realized losses, no corrective duties arises, even if the act constituted a moral wrong. We might owe people other things, but at least not corrective duties as far as the continuity thesis says we do. So how do we kind of get around this issue? So if the continuity thesis requires actual breach, then clearly it cannot easily generate secondary duties for pure risk cases. So should we just accept that cases of wrongful pure risk fall outside the scope of continuity thesis? Maybe we can explain away the compensation duties, if there are any, through other sort of justificatory means. I'm sure that's possible, but that's kind of not the road that I'm going down today, at least not in this paper. And I'm also not sure whether we should so quickly and immediately reject the case for corrective duties in case of pure risks by rejecting its sort of relevance to the continuity thesis. I think there's a way in which we can read the continuity thesis that allows us to make that case. And for whatever time remains, I'm just going to try and do that. So Steele's kind of what I'm calling this outcome-dependent critique tries to tie continuity in the sense Gardner is talking about to the effects of an agent's wrongdoing. But in that critique, what gets overlooked is this idea of persistence of wrong explaining or wronging explaining reasons that underlie the primary duty, which are the central kind of idea or insight that the continuity thesis tries to capture. So I think Steele's also wrong about a couple of other things, like conflating undoing wrongs with undoing losses, but I'm not going to get into those details. What does still matter to me is this overlooking of this idea of persistence of the explanatory reasons that underlie the primary duty. So if the continuity thesis deeper inside lies in this idea, then in some idea about realized outcomes that are instantiated upon breach typically, then I think there's a way in which we can reshift our focus and consider the case for how the thesis is still extendable to cases of pure risk. So the picture is very simple, somewhat simple when it comes to standard actualized harm cases, right? So you breach a primary duty, let's say not to harm. The reason grounding that duty persists demands a secondary duty of repair, very simply, straightforwardly put. And the thesis, the continuing thesis explains that transition from non-conformity with the reason to the requirement of renewed conformity, so compensate or repair. But in pure risk cases, we get a contrast. The harm doesn't occur, so the primary duty isn't exactly breached in the traditional sense. The outcome-dependent critique, however, seems to assume that the grounding moral reasons that are underlying the primary duty have somehow now expired when the harm didn't occur. And that sort of idea already feels somewhat in tension with Gardner's idea about the persistence or the continuity of reasons. So as I've claimed following my simple account, one has failed or properly kind of appropriately conform to the underlying general moral reason. In my case, I say that reason is a general moral fact that for any agent A and B, A is harming B is pro tanto wrong. The agent has failed to be properly or appropriately be in conformity with that reason. And that grounding reason still continues to demand some conformity post-breach, even if the harm does not materialize. And I think that it's this persistence of reason that could potentially trigger the possibility of a secondary corrective duty that arises not because the harm failed to occur, but because the general moral reason remains unconformed to. But at this point, you might immediately object, saying, well, but no primary duty was breached, so how could any kind of continuity hold? And sort of the best kind of response that I've so far managed to think of is that the next best conformity to any unsatisfied reason does not, I think, require full harm to have occurred. What it only requires is a failure to conform to the relevant underlying moral reason. That is, the act of pure risking already constitutes a partial nonconformity with whatever reasons explain the wrongness of actually harming, even if that harm does not eventuate. So there is something that continues onward, not the realized wrong, but the unfulfilled demands of the underlying reason that ground the wrongness of pure risking. And as I said, those reasons are directly the reasons that ground the wrongness of they're grounded by the general moral fact that harming is wrong. Generally speaking, I think this is how theorists kind of get off the boat when it comes to cases of pure risk. They seem to reject the corrective case for pure risk by equating the absence of materialized harm with the absence of yet to be conformed to reasons against harming others that post-wronging, in my picture, continue to demand conformity. Even in the absence of that realized harm, it remains the case that the wrongdoer's relation to that reason, constituted by the grounded fact, which I've explained how it obtains from my account, was in fact disrupted. She had failed to conform, to act in accordance with them or in conformity with them, even though it turns out, the state of affair turns out such that no actual harm was realized. That's still kind of, there's still one important question remaining. So even if this story is somewhat plausible, on sort of Gardner's picture, we still want to know, what does that next best conformity mean? So even if we agree that pure risks are wrong, they sometimes involve wronging others, the continuity thesis in some cases can sort of be made plausible to make the claim that these cases of wrongful pure risking triggers secondary duties. We still have to ask the question, well, then what exactly does next best conformity mean in cases of pure risk? And from the picture so far, I think a very sort of natural suggestion follows. So in the cases of actualized harm, the demand for conformity takes the form of a duty to compensate. So it's very broadly understood as restoring as far as possible what has been lost because of the breach. And the proposal then that I'm trying to put forward is that if the same underlying moral reasons ground both the wrong of harming and the wrong of risking harm, then it's at least plausible that this demand should likewise call for next best conformity after wrongful risk imposition, other things being equal at this point. Which is to say that if an agent A wrongfully exposes B to a risk of harm, then A's non-conformity to those underlying reasons triggers a duty of repair grounded on the persistence of the same moral reason that underlies compensation in the case of actual harm. And the natural kind of analog to compensatory repair here that I'm drawing upon is that the risk imposer has to internalize the expected cost of the wrongful risk imposition. So compensation here would, of course, not involve compensation for the full harm, because as we know, that has not realized, but the compensation for the risk-weighted expected loss that could have realized. And this at least gives rise to some pro tanto duty of expected value compensation that's proportional to, let's say, the magnitude of the risk harm, the probability of realization, and perhaps even some other factors that might determine the both the strength of the duty, but also sort of its scope. So whether the risk was taken voluntarily or it was foreseeable that the harm may realize, and so on and so forth. And this gets very close, at least in the philosophical literature, to the kind of proposal David McCarthy was trying to propose by calling it the direct payment rule, that if A risks harm upon B, wrongfully so, then A owes B full compensation. A further way to kind of motivate this is to say that in general, risk imposers ought to externalize, the risk imposer in these cases externalize the expected cost of their risky conduct without justification. So by exposing someone to the expected cost of a potential harm, risk imposer essentially treats the other as a means to their own end. And you could maybe, bring in your favorite kind of deontological story here to try and further the argument that it does seem that the risk imposer does owe some kind of compensation, but in proportion to the expected loss, not the full loss. Now, some sort of theorists in the literature who've dealt with the question of what we owe in cases of pure risk have reached a different answer. So a very common answer that I've observed is that some people defend different versions of what you might call a duty to contribute, which roughly requires that the pure risk imposers contribute to a compensation scheme or a risk pooling system that would eventually and ultimately compensate for some future harm if and when that realizes. So the imposition of risk merely triggers some kind of payment that they ought to pay, but that payment ultimately gets utilized for compensating some harm that may realize either for the same person who was wronged or perhaps for some other person who was in a similar position if they were wronged by someone else. People kind of vary on the specific details of sort of what they understand this duty as. Some think it's a non-compensatory duty, something that's already compensation for pure risk. I'm not going to get into details of all of them, but just to give you a contrast of what other people have defended, I'll just pick on a very recent sort of similar idea that was argued by Adam Slavny, who kind of argues for this non-compensatory duty by rejecting the compensation case, but does so not by appealing to the continuity thesis, but something that he calls a responsiveness thesis, which is supposed to be an alternative to the continuity thesis. And the idea there roughly is that instead of talking about like continuation of some kind of reason that survived the breach of the primary duty, the secondary duty is really to be understood as a way to give higher, sort of greater respect or greater attention to the values that were underlying the primary duty. So it kind of moves away from the reason talk to the value talk, but essentially still tries to explain what the relationship between these two duties is. And on that account, Slavny argues that what we get in cases of pure risk are not compensatory duties, because he still accepts this more harm-based paradigm of what compensation is required by, and thereby rejects that clearly compensation cannot be owed in cases of pure risk because the harm is not there. But he does say that that doesn't mean that people owe nothing. What they do owe are these contributory duties of equivalent protection that will ultimately then be used for compensating those who in fact get harmed. Now, if the idea is that the compensation claim is sort of too radical, perhaps for some people to attend to, then the next best thing that individuals can do is at least contribute in the form of, let's say, premium payments or buying someone insurance who they've imposed risks onto. And I think that suggestion does much better than those who claim that we ought to do nothing at all in cases of pure risk, but it still doesn't get to the heart of the issues that are initially raised by why we think pure risking is in fact morally significant. So by the very virtue of the fact that the compensation ultimately is for the harm, it seems to water down or ignore the serious moral significance of risk itself that a lot of different theorists have tried to motivate by arguing that the risk itself is wrong because of detrimental effects on people's autonomy. If pure risk, in fact, reduces people's autonomy, then that already qualifies for a kind of compensation, if insofar reduction of autonomy is a form of harm itself. So even then, just mere duties of contribution doesn't really at least satisfy the full claims we think the wrongness of pure risk generates. But also a duty to contribute as an alternative to duty to just compensate for the expected loss would in fact not always be extensionally adequate, because the proposal really depends on there being some future risk that does get materialized. So you can think about counterexamples where people are only subject to one-off but very serious risk, but because of the fact that there is no future risk that could potentially be compensated, any claims they might have for any correction for the wrong that's done to them immediately gets unaddressed because they fail to then become part of that social system that compensates only for the harm. They're completely removed from that system entirely. So in response to this alternative, before I end, is that the continuing thesis may support these contributory duties, but I still think that it would be in those cases where direct compensation, which I think seems more plausible, turns out to be infeasible or perhaps impractical. And still there would be several significant issues to resolve, such as the question of whether these duties do in fact really respond to the serious moral significance of wrongful pure risks itself. So just sort of conclude, I've talked too long, I believe.
That's fine.
Pure risk imposers may sometimes incur corrective duties to compensate. And that kind of goes against claims made by various thought theorists and even some philosophers. That claim shifts the question, at least from my account, from whether they owe such duties to the question of when and under what circumstances such duties are owed and ought to be institutionalized. And I do still sort of, this is something perhaps we can get into the Q&A, but I don't want to claim that any other institutional constraints would be outweighed just for the sheer fact that pure riskers ought to compensate. I think they can still, these constraints may still provide an all things considered case against the case for compensation of pure risk, but at least the burden of proof might shift, or at least that's part of the attempt that I've tried to make in that. Thank you for listening.
Thank you for this very rich and very thought-provoking presentation.